Today's discussion is I found it online so it's free, intellectual property, or how to be a patent troll. The general idea behind patents is to provide an economic incentive for innovation. Innovation is, of course, beneficial for society at large, and patents have developed as a way to provide an economic reward for inventors by granting them exclusive rights over their creations for a given period of time. This system allows both the individual and society to benefit, and serves to further stimulate innovation. With the expansion of the tech industry in recent decades, though, the current patent system has faced new circumstances that undermine the traditional balance between inventor and society, especially regarding patenting software. In the following discussion, we will examine the growing set of challenges that face software patents, and we will look at how patent trolls have begun to target startups in particular.
Patent assertion entities, also known as patent trolls, are companies that only make money from suing other businesses for patent infringement. They have been a problem for businesses for decades, but have been a particularly bad problem for the tech industry, to the point that 84% of patent lawsuits filed in the high-tech industry are filed by patent trolls, with less than 1% of these cases actually resulting in a patent infringement. These patent trolls bank on the defendants settling out of court in order to avoid the high legal cost of defending themselves. With over 10,000 companies having already been sued at least once by patent trolls, it doesn't matter what size your company is, what you make, or what you sell, any company could be a potential target for a patent troll. Over half the companies targeted by patent trolls are considered small businesses, with an average cost of $3.2 million to defend yourselves in a patent troll lawsuit. Many small businesses can't survive unless they give in to the patent troll's settlements. Even for larger companies like Apple that deal with many of these patent lawsuits every year, the cost and resources is high. These suits have taken away $211 million in payments that could have been spent in research and development. 80% of the patents being sued over aren't even produced by the patent trolls themselves. Their patents are acquired from other operating companies.
Now we're going to start talking about some of the problems with software patents. One of the major problems is short innovation cycles. Because of how fast technology changes, most commercial software has a very short lifespan, usually only of a couple of years. This means that it's best to get the software out as soon as possible and be the first to fill the specific void in the market. However, going through a patent process takes time, sometimes even up to 4 years to resolve the patent application. By this time, most software will be obsolete, at least in some aspect. This just is not a viable strategy for software like normal physical products. If you wait long enough for patents, you'll more than likely be beaten to the punch. So this leads us to our first discussion question. How could we adapt the patent system to better handle the rapid life cycle of software?
Another problem with software patents is the fact that software will still be produced without any patent incentive. This is because many aspects of software are already covered under copyright law, which makes patents less useful right out of the gate. Another aspect is the idea that trade secrets can help protect your software. If someone doesn't know how you did something, filing a patent for that idea probably wouldn't be the best thing to do, since your idea will then be published by the patent office for the world to see. Another option for software companies is to lock customers into their own domain. An example of this would be a company using a proprietary file format or proprietary hardware so that their customers couldn't use anything but their hardware or software. Take Photoshop's PSD file format as an example. It is a closed, proprietary file format that can only be opened with Photoshop, essentially locking all users with PSD files into the Photoshop domain. Another example of this is Microsoft's audio format WMA, which is an entirely closed format. Lastly, let's not forget that probably the greatest software project to date, Linux, is a completely free and open source product with no patenting involved. Instead, Linux uses the GNU General Public License 2.0, or GPL2, which essentially says that you can copy the source code however much you want, but any derivative works which include Linux must also adhere to the GPL2, thus keeping any future iterations or derivatives of Linux's open source code open and free. Which leads us to our next question. Do you think that copyright laws can take the place of patents on software, or do you think that we will always have a need for patents on our software?
Other issues with software patents is that there are many overly abstract patent claims. Most of the patents for new software or software features are not really new or different from existing ones. Some patents are just for basic common concepts. Many companies have difficulties in explaining what is innovative about their software and its features. In order for a software to be patented, it must meet several criteria. One of them is being that it has to be new and original from existing ones. This leads for owners to provide exaggerated interpretations in their patents, even if it's just for the slightest changes and difference in their software. Also, changes in the software industry outpace patent databases on prior art. The process of patenting a software and its research is expensive for developers, which does not include the patent lawyer fees. Some of these patents range from 6,000 and it can go up to 20,000. And again, this does not include the fees for the patent lawyers. Another issue is that it leads to conflicting claims between its holders, the patent holders, and its new innovators. A patent can apply to just a small function or feature, which can be expressed in the slightest change in code, or it can be expressed in a few lines of code, where as an application with millions of lines of code sometimes cannot be patented. Which leads us to our next discussion question. Is there a fundamental difference in describing software, or is it a technological illiteracy?
In this section, we're going to be talking about how patent trolls operate and more specifically how they target startups. So, patent trolls typically use shell companies called patent assertion entities whose main goal and job is to litigate over patents. So basically sue other companies patents that they come up with, even though they don't actually make any products. Um, and their typical target would be smaller companies that don't have as much money or assets to even pay for the defense for these types of cases, because they aim to settle outside of court, because of course these smaller companies cannot pay to for the defense. This is what makes startups the perfect target, just due to the fact that they don't have the assets or the legal team to defend themselves in this sort of case. Fortunately, there are resources out there that offer protection for these startups and small companies against patent trolls. They're called patent protection networks. I know one of them is called LOT Network, and they're actually free if the company has under 25 million in revenues. There are other resources out there, and some of them do charge fees, but the fees are cheaper than a lengthy battle in court. So that leads us to our first discussion question. Do you think there are any downsides to participating in a patent protection network?
How can the government tackle the problem of patent trolls? How would you like to see software innovations protected? Adapt existing protections or develop a whole new system?
In conclusion, we have seen a number of issues facing the patent system as it regards the software industry. The fast pace and rapid turnover of software disincentivizes filing for traditional patents and outstrips the pace of the patent application process. In addition, abstract and imprecise language in software patents leads to ambiguous interpretations and conflicts between current patent holders and potential new innovators. In recent years, an industry of patent trolls has developed to exploit these issues by threatening expensive litigation against companies in exchange for monetary settlements. Patent trolls especially target vulnerable startup companies with limited legal standing and resources, and they pose a serious threat to future innovation by potentially fatally undermining emerging technologies. As students of computer science, and potential future innovators ourselves, it is especially paramount that we recognize and understand the issues confronting the current patent system, and that we work to develop better and more adaptable solutions to protect both individual innovators and societies as a whole.